Hi, it's Richard Hughes with the Hughes Law Firm. I am here with John Campbell of Counsel to the Firm, and we are going to do another segment of our series entitled Solutions. John, I want to give you a scenario regarding a single woman who is failing and frankly needs nursing home care. Her daughter, Betty, has been trying to take care of her for quite a while, but it's become too much of a burden. Betty's got her own kids, she's got her own spouse, she's got her own family, she's got her own burdens, and taking care of Mom any longer is just an impossibility. Her mom, Mary, has a home worth $300,000. It's free and clear. Mary, mother, also has $200,000 left of her savings. Now we want to see if we can figure out how to get Mary some Medicaid benefits as soon as possible. Give me a scenario, a solution, an answer to this conundrum. She's overqualified because she can only have $2,000 in cash, but she's got $200. So take it from there.
Well, there's actually two sides to this issue. One side is the question of eligibility. How do we get Mary eligible? But we also have a spectral side to this. And we haven't really talked about this before, but it's the idea of Medicaid estate recovery. If Mary goes into a nursing home on Medicaid, then the moment Medicaid starts paying benefits, the Medicaid agency starts to accrue a claim. And when Mary dies, they can execute that claim on any property that was in her name when she died, and that goes through her probate estate. So we could just get Mary eligible by reducing her cash assets because the house won't count for eligibility, but it's a $300,000 asset that after Mary dies will be exposed to that estate recovery claim if we don't plan with it now.
Now that's pretty scary. I think a lot of people think that a house is exempt, which means it's exempt and it's safe. But for a single person, when a single person, let me make sure I hear you correctly, when a single person gets Medicaid, but they still have a house, they can qualify for Medicaid, but Medicaid's payments to the nursing home for that person's benefit really look like only a loan. Well, because then Medicaid wants the money back by going against the house after Mary dies.
Well, if it's Medicaid in a nursing home, that's true exactly the way you described it. But just as a technicality, if they receive Medicaid benefits outside of a nursing home, at home, then that Medicaid estate recovery claim only begins to accrue when benefits are provided after age 55.
Okay.
But yeah, but we've definitely got a estate recovery issue here. So what I would suggest in a case like this, Mom has enough cash assets to where she could make a gift of an interest in her home that would be, and still have enough cash assets to purchase one of those Medicaid-friendly annuities to cover the transfer penalty period.
Caused by gifting the house?
Caused by an interest in the house. Not the whole house. $300,000 gift she wouldn't have enough to cover. What we often do in a situation like this is divide the ownership into the house between what's called a life estate and a remainder interest. The life estate is the right to occupy and use and live in the premises as long as you live. And we have that stay with Mary. But she can give that remainder interest to her daughter. The remainder interest, depending on Mary's age, may be anywhere from 45 to 65% of the value of the whole house, rather than a $300,000 transfer. We may be talking about $150,000 or $200,000 transfer.
So if she gave away,
so she has enough other assets to cover that penalty.
So if she gave away a remainder interest of the home to her daughter, and that remainder interest was equal to 2/3 of the value of the home, she'd be making a gift of 2/3 of $300,000, which is a gift of $200,000.
Exactly.
And then we use her cash assets of $200,000 to do what with?
To purchase one of those Medicaid-friendly annuities so she doesn't get left out in the cold during that penalty. The reason this works is because Medicaid estate recovery is limited to what goes through a person's probate estate. A life estate remainder arrangement in real estate does not work that way. When a person with a life estate dies, their interest dies with them. And now the person who owned the remainder all the time now becomes the owner of the full value of the real estate without any probate. So what we've done is we've arranged for $300,000 worth of resources to go to the daughter, and have only incurred a $200,000 transfer penalty for doing it.
Well, that's fabulous. So the life estate interest is a way to avoid estate recovery by avoiding a probate, so Medicaid can't glom on to any value of the house.
Right.
And then when we make a gift of a remainder interest in the home, which in my example calculated out to be $200,000, that would in essence penalize Mary from Medicaid for about 30 months, 25 to 30 months, without doing accurate math. But then you use the Medicaid-friendly annuity to have it then pay the cost of the nursing home for the 25 or 30 months, and then bingo, Mary qualifies for Medicaid, and we have protected about $200,000 of this estate, plus the remainder interest.
We've protected 300.
300, the house, 200, and the remainder, and the life estate interest of 100. So we've saved 50% of the value of this estate, where many times folks will simply allow a complete seizure of the home after death and spend down remaining assets without knowing they had the ability to plan in advance if they would just contact a pro who does this every day and helps people save literally hundreds of thousands, if not millions of dollars every year. So if you need some help in this area, I know this segment's been a little long, but it's tricky. You know that. That's why you know you need some big time help. Contact us. We'll show you the ropes.